Hello everyone, welcome to Learn Law with AKP. In today's class, we will discuss personal liability of agent under the Indian Contract Act 1872. Generally, an agent acts on behalf of the principal. Therefore, contracts entered into by the agent usually bind the principal and not the agent personally. However, there are certain situations where the agent becomes personally liable. This topic is very important for semester examinations because students are frequently asked to explain the exceptions to the general rule. Let us begin. Here, the general rule is contained in section 230. According to this section, an agent cannot personally enforce contracts entered into on behalf of the principal. Similarly, the agent is generally not personally bound by such contracts. For example, a sales agent purchases goods for a company. If payment is due, the company is liable, not the agent personally. Therefore, agency normally protects the agent from personal liability. Now, why agent is not personally liable? The reason is simple. The agent acts merely as a representative. The principal receives the rights and benefits arising from the contract. Therefore, the principal should also bear the liabilities. The agent is only a connecting link between the principal and the third party. Now, we are having the exceptions, and one important exception arises when the principal resides abroad. A third party dealing with a local agent may find it difficult to sue a foreign principal. Therefore, the law presumes that the agent may be personally liable. For example, an Indian agent enters into a contract for a company located in another country. If the contract is breached, the agent may be held personally liable under certain circumstances. Now, another exception arises when the principal is undisclosed. The third party does not know that the agent is acting on behalf of someone else. As far as the third party is concerned, the agent appears to be the contracting party. For example, Shyam purchases goods without revealing that he is acting for Ram. The seller believes Shyam is the actual buyer. In such cases, Shyam may become personally liable. A third important exception occurs when the principal cannot be sued. This may be happen if the principal lacks legal capacity or cannot be identified. In such situations, the agent may be personally liable because otherwise the other party or third party would be left without a remedy. Now, express agreement. An agent may also become personally liable through an express agreement. If the agent specifically agrees to assume responsibility, the law will enforce that promise. For example, an agent signs a contract stating that he personally guarantees performance. In such case, the agent cannot later deny liability. Now, Section 231 protects third parties when an undisclosed principal is discovered later. Even if the principal becomes known afterward, the rights already acquired by the third party remain protected. The law attempts to balance fairness between all parties involved. Let, let us understand through a practical example. Ram appoints Shyam as his purchasing agent. Shyam purchases goods from Ravi. Normally, Ram is liable because he is the principal. However, if Ram's identity was hidden or Ram resides abroad, Shyam may be personally liable. This example clearly shows the difference between the general rule and its exceptions. Now let us understand an important case law. In Humble versus Hunter, a person entered into a contract while describing himself as the owner of the ship. In reality, he was acting on behalf of another person. When a dispute arose, the question was whether he could later claim that he was merely an agent. The court held that because he represented himself as the principal, he could not escape liability by later claiming agency. Here, the principle established is a person who contracts as a principal may become personally liable even if he was actually acting as an agent. This case is frequently discussed while studying personal liability. Now, let us quickly revise. The general rule is that an agent is not personally liable. However, important exceptions include foreign principals, undisclosed principals, principals who cannot be sued, and situations involving express agreements. Remember these exceptions carefully. Now, for examinations, always remember section 230, the general rule and the exceptions. Section 231 and the important case law, these points will help you write a complete answer. Let us conclude today's topic. The general rule is that an agent is not personally liable because he acts on behalf of the principal. However, exceptions exist where fairness requires the agent to bear responsibility. We also studied the important case law of Humble versus Hunter and understood how personal liability can arise. Therefore, while the law generally protects agents, certain situations create personal liability. For examinations, remember general rule, exceptions, examples, and case law. Thank you for watching. If you found this video helpful, please like, share, and subscribe to Learn Law with AKP. See you in the next class.